would like to talk about equality and discrimination. And I'll try to show how these two principles were very important in not only protecting individuals and groups, as it always happens when these principles are applied, but also was a very, very big component of the construction of European integration. And I will try to show why and how this happens. I will then talk about some important decisions of the European Court of Justice. Perhaps you could have found that they are described too much in details in the written text. So don't worry, I'm not going to do the same mistake again. I will talk widely in general terms about those decisions. And at the end, I will also try to make some personal reflections on all this experience. My text starts by describing a feeling which was shared by many legal scholars, European legal scholars, a feeling of disappointment about the enactment. Well, the enactment actually gave space to a sense of excitement of the 2000 directives, anti-discrimination directives. So the first feeling was of exciting, and then what arose was a sense of disappointment. The sense of excitement was due to the fact that, as I will say later, for a long time, anti-discrimination protection was only restricted to two fields, which were nationality and gender. While in this new generation, we call them new generation directives, the scope of protection enlarged very much to factors such as race, ethnic origin, sexual orientation, age, disability, personal beliefs. So there was a sense that at the end the European Union was ready to face some of the most serious sources of discrimination as discrimination takes place in society, in European society. The sense of disappointment arose because, first of all, because in something like 15 years, there have been just 40 cases which have been decided. 40 cases which have been, I don't have a microphone, I'm afraid, so you cannot hear me? I can try to speak a bit. So I was saying that there were, in 15 years, there were just 40 cases decided by the European Court of Justice. And out of these 40 cases, the majority of cases were about age discrimination. So we only had, for example, one case of race discrimination decided by the European Court of Justice. It was a very innovative decision. I don't know if we will have time to talk about that, but it was just one. While at the moment we are experiencing one of the most serious, one of the period of the most serious racism and xenophobia showing itself in many European countries. So this is a big problem at the moment. But we only have one case on race discrimination. Well, the other reason of disappointment was that there are actually kind of inconsistency in the European Court of Justice decisions. So it's not quite clear, for example, which is the meaning, which kind of scrutiny the European Court of Justice is going to apply to all these grounds. As you know, constitutional courts, referring to this kind of treatment, so treatment which are based on what are called suspect classifications, tend to apply stricter scrutiny on differential treatment which are based on this kind of grounds. It is not clear if the European Court of Justice is going to do the same for all types of grounds, or if referring to some grounds, for example, age, it is going to apply a less severe kind of scrutiny. Another thing which is not clear at all is which is the relationship between the general principle of equality and the specific grounds of discrimination. So there are many reasons for being in some way disappointed about this first period of implementation of this new type of anti-discrimination protection, but what I would like to argue is that perhaps we can look at this kind of inconsistency as a sign of something which is going on and is perhaps a little more complicated, just having a court which has not taken the decision about where to go in interpreting the new legislation. And why I'm saying so? My argument is that we can look at this type of dialogue which is going on not only inside the European Court of Justice, which is composed by many judges coming from different national experience. So you have to imagine that the court is composed by judges coming from all the member states of the European Union. It's not just a matter of diversity. The problem is that what is going on is what I call a negotiation between, first of all, between the European Court of Justice and the national courts, especially constitutional court. And secondly, the negotiation is going on between the European Court of Justice and the political actors, which not always have accepted what the European Court of Justice has said about what they are doing as legislators. And the second thing that I will try to show is that in any case we can see signs of an innovative approach to equality and non-discrimination, and it seems that the court is ready to play what I believe is one of the most important roles that a court can play in applying the anti-discrimination protection. That is a counter-majoritarian role. The court is protecting minorities in a way which is quite new in the European experience at the level of the European Union. So let me start just for giving you the sense of this change. Let me start from the beginning. Let me give you a brief history of the principle, which was the beginning, the rationale for the European anti-discrimination law. Well, the first rationale was an economic one. If we look at the national constitutional orders, and then we look at the European legal orders, and I don't know actually how much you know about that, but you surely know that at the beginning the Treaty of Rome was mainly aimed at building a common market. This is a way of describing the beginning of the European integration, which is quite ordinary. It is quite normal to describe the beginning like that, but it's also in some way misleading, because if we look at the decision which lie behind the decision of building a common market, actually they were political, even moral, I would say, because what lie behind the decision of constructing a common market was the desire to avoid what has been for the generation, in which case before my generation, was a tragedy. I'm referring to the Second World War, which was fighted among European states. That seems incredible now, but what happened the last century. So it is true that the treaty was first aimed at building a common economic market, but this was thought as a way of constructing a more a political community, if you wish. So why then the founders decided to provide also protection against discrimination? Well, because discrimination was seen as an obstacle to the construction of a common market. Let's think, for example, of a worker who decided to exercise his freedom of movement from one country to another. Would he or she really be able and willingly to really exercise this kind of freedom if she or he had found a difference in treatment, for example, in pensions or in working conditions once arrived in another country? And also referring to enterprise, can be said the same. An enterprise would not exercise the freedom of settlement of an enterprise in another country if they found a different treatment as an economic actor. So actually we usually refer to the function of the anti-discrimination protection as a functionalist function. Anti-discrimination protection was intended as a way of avoiding obstacles in the construction of a common market.
It's unusual, but can I ask you, because this rationale explains nationality,
And
but
gender.
why gender?
Well, it will take a while.
Okay.
So if you are going to
No, maybe in the Q&A.
It's a very interesting story. Why? Can you imagine why? For example, if I say the word social dumping, does it make any sense? Does it tell you something? Let me now talk a different frame. So at the beginning, the anti-discrimination principle was seen as a way of facilitating economic integration. What happened then was quite different, because the Court of Justice, which is a very important actor of the process of integration, the European Court of Justice pushing hard to facilitate integration, to push that, to make stronger the European level government. The European Court of Justice started to interpret in a quite different way the anti-discrimination principle. First of all, start to look at this principle not only as a rule of treatment. This refers, perhaps we can go back to these two meanings of the equality principles. It's not using the equality principles as a rule of treatment, as an objective rule of treatment, but using the principle of equality as a fundamental right, as a personal fundamental right. And the first step was reading these two prohibitions. So we didn't have a principle of equality enshrined in the Treaty of Rome, but the Court of Justice started reading these prohibitions as a particular expression of a general principle of equality, which the Court said, though not explicitly enshrined in the treaties, is a fundamental principle of community law. And this was important. Why? Because by doing so, the Court of Justice was able to exercise the kind of scrutiny that all constitutional courts are able to exercise towards any kind of law, not only to law referring to a discrimination. And the second step, which really gave a different meaning and also a different vision of this prohibition of discrimination, was to look at the principle of equality as a fundamental human rights. This happened in a case which refers to gender discrimination. And the Court says the economic aim is secondary to the social aim, which constitutes the expression of a fundamental human rights. So really, the Court changed the original meaning of the prohibition of discrimination. So we can conclude on this point by saying that the norms, which were at the beginning conceived as instruments of economic integration, has ended up acting as vehicles of social integration and protection of human rights. This is very clear in a case which I can describe unfortunately, but was a P case referred to a case of gender reassignment. So here the question was, does gender, the prohibition of gender discrimination also refers to gender assignment? And the court gives a very large, very wide interpretation of the term gender, using the dignity argument in the P case, which was a case of gender assignment. The court says in a sentence that I often quote because I like it very much: to tolerate such discrimination would be tantamount, as regards such a person, to a failure to respect the dignity and freedom to which he or she is entitled and which the court has a duty to safeguard. This is one of the decisions which make me feel a fan of the interpretation of dignity as autonomy, I must say, because this was the court was able to enlarge the meaning of discrimination to cover also gender identity-based discrimination. So far the court was very brave in enlarging the discrimination protection. But then there was a reaction from the member states who said, wait a minute, you are enlarging the meaning of this prohibition much beyond what was intended by who make the laws. The master of the treaties. You know what the masters of the treaties? It's a very powerful expression. The master of the treaties are the member states, are the political actors. And they were saying to the court, we are going too much behind. So the courts, as it happens, yes. So in ground, the court backwards. They said, I'm not going to protect, to enlarge the meaning as to protect homosexuals as well. Because what can be said on this point, the court needs consensus and legitimation in order to enlarge the meaning of legal terms. And this legitimation came at a certain point from a new generation of anti-discrimination law. So what happened with the Treaty of Amsterdam, which was one of the treaties which changed the European integration, not going through telling the story also of the Treaty of Amsterdam. I'm not only saying that the Treaty of Amsterdam extended the scope and depth of the anti-discrimination principle because it introduced a new provision, Article 13, which is now Article 19, which says that the European Union has the competence to take appropriate action to combat discrimination based on sex, racial or ethnic origin, religion or belief, disability, age, and sexual orientation. I would like you to note the language of this provision. The European Union has the competence to take appropriate action. This means that this provision is giving power to a public and political actor. It's not recognizing an individual rights to be protected against discrimination. And we can go back later to this. But perhaps the strongest criticism and the most severe criticism was made in a decision called Chakonava decision by the Advocate General Guilhold, which says the court is here using the general principle as a lever, as a Archimedean lever, to break the division of competence, that means the division of power between member states and European Union. So again, there was a warning. Since the European Union is made by quite wise persons, they could then took a more cautious approach in the following decision, which I'm not going to describe. What I can say is that we, and this refers a little bit to the title of my presentation, we are now dealing with a wavering judicial doctrine. So in some cases, the court stepped back and said, well, we have to wait for the member states to give effect to what is decided at the European level. So, for example, we have to wait and see how the member states implement European law. While in other cases, and this again refers to gender identity, the court kept on saying what is decided at the supra level, the supranational level, since it refers to general principle, to fundamental rights, it applies no matter what the member states decided at the national level. And there is a very recent case, Associé de Médiation Sociale, where the courts also referred this kind of factor to the Charter, saying that the prohibition of, in this case, non-discrimination on the basis of age, the Charter, so the European level is sufficient to confer an individual rights which they might invoke as such, no matter what no matter what the member states do or say. So the last part of my presentation would have been on how to solve this kind of conflicts, and also to reflect on the counter-majoritarian role that actually the court is playing in this very wavering judicial doctrine. But I'm sure that we can do that in the discussion.